Hello to all my dear students. So we are starting with this revision session where we are going to revise all the entire syllabus of the CA Foundation Law. Not very detailed also, but not very fast also. But we'll be covering up all the topics and the videos are divided unit wise. So you will see all the videos will be discussed as per the units. So starting with today we are going to start with the Partnership Act. So starting with Partnership Act, what is partnership? Partnership is an agreement between two or more persons. What is the agreement about? To share the profits of the business carried by all or any one or more acting for all. So if I look at this definition, what all do I get? First of all, there has to be an agreement, right? First of all, there has to be an agreement. Now, this agreement is between how many people? Two or more persons. What is the agreement about? To share the profits. Where will I get the profits from? From the business. And who will carry the business? It will be carried by all of them, or it will be carried by any one or more acting for all. So the first is agreement. Always remember, partnership can never arise out of status. So just because two people, husband and wife, let's say, carrying business together, by status they are partners for life, but not partners as per Partnership Act. So I need to have an agreement. When I say agreement, the agreement can be express or the agreement can be implied. If it is express, it can be oral or written. And when it is written, the deed where we mention all the clauses of partnership is called partnership deed, right? Then, when I say agreement, obviously I cannot agree with my own self. So there has to be minimum how many two? Maximum is not given under the Partnership Act, it's given under the Companies Act, which is 50. And if at any point of time it is more than 50, it becomes an illegal association, right? What is the agreement about? The agreement is about sharing of profits. Now, they have only said sharing of profits, not losses, because I can have partners who do not share the losses. But if I put it sharing of profits and losses, that means I'm making it mandatory for every partner to share the loss. But I actually can have partners who do not share the losses. So sharing of profits does not necessarily mean sharing of losses. But obviously, when you share the profits, you will also bear the losses. But it is not implied that you will bear the losses. When I say sharing of profits, profits are shared in the ratio agreed. And if nothing is agreed equally, but when we talk about losses are shared in the losses are shared in the agreed ratio. And if nothing is agreed, we don't say equally, it is shared in the PSR. So if nothing is given about the loss, the same ratio as we share the profits, we also share the losses. Now, where would we get this profits from? Business. So what is this business? Business could be any trade, profession, or occupation, but it has to be recurring in nature. And it has to be an economic activity with the motive to earn profit. Here, one thing is very clear. They have talked about rent. Renting of property is never considered as a business. So, if I rent my property to earn money, this will not be considered as a business. Last, who will carry this business? This business will be carried by all the partners together or any one or more of them acting for all. So, let us say, just one second. So, let us say A, B, C are partners of the firm. So, all the three A, B, C has a right to carry the business, correct? But can A, B, B, C, A, C alone carry carry the business, leaving one of them? Yes. Can A alone carry? Alone, yes. A can even alone carry the business. Now, when A carries the business, he acquires a twofold character, as in he is both the agent as well as the principal of the other partners, right? Is the agent as well as the principal of the other partners. Now, when we talk about agent as well as the principal of the other partners, in this case, why we call him the agent, why we call him the principal? Let's say he is dealing with T on behalf of his other partners, right? He is their agent. But when he is dealing with T on behalf of the firm to T, he is the firm. So he is both the agent as well as the principal. So you know what? Whenever you get a question on implied authority of the partner or any contract which is made by the partner in the name of the firm, and the question is like, is the partner liable? You can always start with a partner for the purpose of the business of the firm is both the agent as well as the principal of the other partners. is both the agent as well as the principal of the other partners. Now, when we talk about this partner, when A does the act, okay, is he alone liable or the whole firm is liable? The whole firm. We have done this concept in agency. Agent does the work, principal is liable. Partner does the work, firm is liable. On this grounds, we can say that partnership is an extension of the law of agency, right? Extension of law of agency. And this is the cardinal principle, that is the most important element of partnership. This is the most important element of partnership, right? Now, moving forward, what is, see, if the agreement is written, I know there's a partnership, but if the agreement is not written, how will I know whether the partnership is there or not? If the agreement is oral, if the agreement is implied, how am I supposed to know whether there is a partnership or not? So what is the test for partnership? So we have to determine the existence of the partnership, we have to look into the real relation of the partners. We have to look into the real relation of the partners, taking all the relevant facts together. Taking all relevant facts together. So, to check whether there is a partnership or not, what all should be present? First, there should be an agreement. That agreement must be to share profits. Profits will come from the business, and the business will be carried by all or anyone or more acting for all. When all of these are present, we can say there is partnership. But let's say there is only sharing of profits. Is sharing of profits alone are considered as partnership? Let's say I've hired a manager, okay, I've hired a sales manager, and I tell him that I will pay you commission on the basis of the profit that you earn for me. Now, in this case, he's getting a share of the profits, but does he become the partner of the firm? No. So he's sharing the profits, but he's not the partner. So sharing of profit alone cannot be considered as an evidence of partnership. For partnership to exist, I need sharing of profits, and along with that, I also need mutual agency. When both of it is present, then I can say partnership exists. So, sharing of profits is the prima facie evidence of partnership. The true test is what? Mutual agency. Right? The true test is what? Mutual agency. Now, what are the different types of partnerships that we have? What are the different types of partnerships that we have? You can have a partnership for a fixed period, you can have a particular partnership, and you can have a partnership at will. What is partnership for a fixed period? Obviously, the name is telling it's formed for a period of time. Who decides this period? Nothing is given, the partners will decide, right? Who decides this period of time? As such, nothing is given in law. Partners will decide. It can be for a day, for an hour, or even for years or months. What happens once the period is over? The firm is dissolved. What happens once the period is over? The firm is dissolved. But if the partners want, can they continue? Yes. And if they continue, it becomes a partnership at will. The next is particular partnership. What do I mean by particular partnership, which is formed for a specific purpose? What happens once the purpose is over? The firm is dissolved. But if the partners want, can they continue? Yes. And if they continue, it becomes a partnership at will. The last one, partnership at will. What is partnership at will? No time is given to determine the partnership. That means we will continue as long as we want. That means as long as the partners want to continue the business, they will continue. But it has a very unique feature. Any partner can give a written notice and retire from the firm or dissolve the firm. Now, what are the different types of partners that we have? Active partner. He brings in capital, takes part in the business, shares profits, known to the outsiders, liable to the outsiders, has to give a notice of retirement. But always remember, when I say active partner, the key thing here is participation in business. Whether the other things are there or not, if he is participating in the business, we call him as an active partner. Doesn't matter if the other things are present or not. If he is participating in the business, we will call him an active partner. What is sleeping partner? Does he bring in capital? Yes. Does he take part in the business? No. Does he share the profits and the losses? Yes. Is he known to the outsiders? No. Is he liable to the outsiders? Yes. Does he have to give a notice of retirement? No. So capital is there, profit is there, liability is there. But does he take part in the business of the firm? No. Is he known to the outsiders? No. Does he have to give a notice? No. Nominal partner. Does he bring in capital? No. I've bought my nominal partner is a person who lends his name to the firm, right? Why would I take your name? Because of your goodwill, right? So he lends his name to the firm. So when I say he lends his name to the firm, does he bring in capital? Does he bring in capital? No, because I've already given you my name. Does he take part in the business of the firm? No, I've already given you my name. If I only have to do the business, I will give you name, I will bring capital, then why do I need you? Right? Does he share profits and losses? Generally, he gets a fixed royalty. But yes, he can get profits, that's different, but generally, he gets a fixed royalty. Is he known to the outsiders? Well, he is a nominal partner. His name is lent. Yes, he is known to the outsider. Is it liable to the outsider? Yes. If he retires from the firm, should he give notice? Yes. So, when we say nominal partner, he is known to the outsiders. He is liable. He has to give notice. But he does not bring in capital. He does not take part in the business of the firm. He does not share profits and losses mostly. Partners in profits only, they only share the profits, not the losses. But when it comes to the liability to third party, they are liable for their share, to their share in profits. They are liable even to the third parties. So liability is something that happens for every partner, irrespective of whether you share the profits or not. Sub partner. What is sub partner? When a partner agrees to share a part of his profits with another. I repeat again, when a partner agrees to share a part of his profits with another. Right? So let's say ABC are partners of a firm and A agrees to share his profit with D. D becomes the sub partner. Now, if he does not get his share, can he sue B and C for his share? No. If there is a loss, can B and C sue D for that? No. So that means he's actually not the partner of the firm, he's just the partner of the partner. Partners by estoppel or holding out. There are two situations here. First, a partner of a firm represents another person to a third party as a partner, and such person keeps silent. He does not deny, right? He keeps silent or he does not deny. So, to the third party, he is a partner of the firm, right? And if the third party contracts with the firm, G is also liable. I'm saying also, firm will be liable because the firm has made a contract, but G is also liable and his liability shall be severe. And when I say severe, it means what? He's liable for the whole amount, right? He's liable for the whole amount. Now, coming back again, when we talk about this partner by estoppel or holding out, let us say T goes and tells E that G is a partner of the firm. Will G be liable to E? No. The presentation was made to T, he is liable only to T and not to any other person. So if T goes and tells anyone else, he is not liable. The next part, let's say ABC are partners of a firm, O is an outsider. O goes to third party T and tells him, I'm a partner of the firm. Now, if T contracts with the firm, T is not contracting with O, T is contracting with the firm. Obviously, when T is contracting with the firm, who is liable? T is contracting with the firm. Obviously, the firm is liable, but O is also liable and his liability shall be severe. So, when a partner of a firm represents another person as a partner to a third party and such person does not deny it, or an outsider represents himself as a partner, such partner's liability shall be severe. And please remember, liability is only to the person to whom the representation is made. Only to the person to whom the representation is made and not to any other person, right? So with this, we are done with this unit. We are done with the first unit. So I'll see you again in the next video with the second unit. Till then, happy learning and stay motivated.